Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
Over the future of gun control in Oregon.
The ruling could jeopardize similar laws in 5 other states.
Everybody has a right if they're a responsible adult.
There's a deadline approaching in Oregon that most firearm owners have completely missed, and when it arrives in March 2026, thousands of law-abiding citizens could suddenly find themselves on the wrong side of the law without ever intending to break any rules. While media attention focused intensely on binary trigger restrictions and magazine capacity limitations following September 26th, an entirely separate layer of regulatory changes has been developing quietly in the background. These secondary provisions affect financial costs, legal liability, proof of ownership requirements, and interstate travel in ways that most Oregon residents haven't begun to understand. The implications extend far beyond what gets discussed in heated debates about Second Amendment rights. We're talking about insurance coverage gaps that could lead to personal bankruptcy, certification programs that don't exist yet for training that's legally required, database systems collecting detailed information on purchases, and compliance costs that could easily exceed $900 per transaction for working-class citizens. What follows is an examination of 7 specific issues that are emerging from Oregon's new regulatory framework, problems that aren't getting attention in mainstream coverage, but will profoundly impact anyone who owns or plans to acquire firearms in the state. The burden of proof that shifted without warning. Grandfathering provisions sound protective in theory, but Oregon's implementation creates a practical problem that most owners haven't considered. The burden of proof has reversed. Citizens are allowed to retain standard capacity magazines that were legally purchased before the prohibition took effect. That sounds reasonable until you realize that proving when you made those purchases now falls entirely on you, not on the state. That receipt from 2019, better hope it's still filed somewhere accessible. Purchased magazines at a gun show using cash, there's no documentation trail. Bought from a private seller years ago, no formal record exists. Made purchases online from out-of-state retailers who may not have maintained records. You're facing the same problem. The Oregon State Police doesn't maintain any registry of pre-ban magazine acquisitions because no such system existed when those purchases were legal. Private transactions, gun show sales, and out-of-state purchases, these represent millions of legally acquired magazines with no paper trail whatsoever. Defense attorneys in California who handled similar cases reported that approximately 67% of their clients couldn't produce sufficient documentation for magazines they'd owned for years. This creates a legal nightmare where law-abiding citizens who acquired property completely legally could face penalties because they can't prove the timing of decades-old purchases. The law doesn't require prosecutors to demonstrate you bought restricted items after the ban. You must affirmatively prove you acquired them before. That's a fundamental shift in how burden of proof typically functions. The financial barrier most people haven't calculated. Compliance with Oregon's emerging regulatory framework isn't merely legally complex. It's becoming financially prohibitive for working-class firearm owners in ways that don't get discussed in policy debates. When you actually calculate the real costs involved, the numbers become staggering. Start with the permit-to-purchase fee, currently proposed at $65 per individual application. Then add mandatory firearm safety training courses, estimated between $150 and $300 based on similar programs in California. Background check processing fees through local sheriff's offices typically run $50 to $75. Fingerprinting requirements add another $40 to $60 at approved facilities. And don't forget the time away from work to complete training sessions, submit applications, and wait for processing appointments. Easily $200 to $400 in lost wages for hourly workers who can't afford unpaid time off. You're looking at $500 to $900 minimum just for permission to exercise what the Constitution describes as a right. Want to acquire 2 firearms? Pay twice, 3, triple the costs. The expenses don't scale proportionally, they multiply with each transaction. For families living paycheck to paycheck, these financial barriers could effectively price them out of legal ownership entirely, regardless of their legal standing or constitutional rights. The training certification program that doesn't exist yet. March 2026 isn't just about new permit requirements, it's about finding someone actually authorized to provide the training that state law will mandate. And here's the problem, Oregon hasn't certified anyone yet. The new permit structure requires hands-on firearms training from instructors who meet specific certification standards, but the Oregon State Police is still supposed to create the certification program for trainers, establish curriculum requirements, and approve training facilities. Current concealed handgun license instructors aren't automatically qualified under the new system. The requirements are different, more extensive, and as of now, largely undefined. There are approximately 340 active CHL instructors operating in Oregon currently. When California implemented its permit-to-purchase system, they required roughly one certified instructor for every 1,200 applicants just to handle the volume. The timeline is compressing rapidly. If the state doesn't establish this certification infrastructure soon, March 2026 will arrive with legal requirements that literally cannot be fulfilled because the authorized instructors don't exist. Citizens trying to comply with the law in good faith will find themselves unable to do so through no fault of their own. The insurance coverage gap. Nobody warned you about. Every firearm owner in Oregon just became a potential defendant in civil litigation, and the vast majority have no idea their homeowner's insurance won't provide coverage. The new laws didn't merely establish criminal penalties, they opened pathways for civil liability that could result in financial ruin even when someone acted completely within legal boundaries. Use a firearm in legitimate self-defense with a standard capacity magazine outside your residence? You might prevail against any criminal charges but still face a civil lawsuit from the person you defended against or their family members. Oregon's new legal framework allows plaintiffs to argue that violating any firearm regulation, even technically or inadvertently, constitutes negligence per se, a legal concept meaning the violation itself proves carelessness, fundamentally shifting the burden of proof. A 2024 analysis by the Insurance Information Institute found that approximately 89% of standard homeowners' policies explicitly exclude coverage for incidents involving violations of weapons regulations. Most firearm owners have never reviewed their policies for this specific exclusion and have no idea they're potentially exposed to catastrophic liability with no insurance protection whatsoever. The interstate travel problem that creates constant legal jeopardy. Oregon firearm owners who travel to neighboring states are discovering their legally owned property becomes problematic the moment they cross state boundaries in certain directions. The regulatory frameworks don't align across jurisdictions, creating legal minefields for anyone who travels. Idaho recognizes Oregon's concealed carry licensing, but standard capacity magazines that are legal in Idaho become restricted the moment you return to Oregon if you transported them incorrectly, according to Oregon's specific requirements. Washington State maintains its own magazine restrictions that don't align with Oregon's provisions. California's regulations are even more restrictive and complex. Consider this scenario. You're driving to a shooting competition in Nevada where your equipment is entirely legal, but the return trip through Oregon requires unloading all magazines, separating them from firearms, and securing everything in different locked containers. Miss one procedural step at an Oregon State Police checkpoint on Interstate 84, and you're facing serious charges despite having broken no laws in the state where you were actually using the equipment. The fundamental problem is that interstate travel with firearms is supposed to receive federal protection under the Firearms Owners Protection Act of 1986, but Oregon's specific requirements create situations where federal protections and state regulations conflict, leaving travelers in legal gray zones. The undefined terms that will create selective enforcement. Nobody can actually agree on what qualifies as a prohibited rapid-fire device under the new restrictions, and that ambiguity will create massive problems through inconsistent enforcement. The law prohibits devices that increase the rate of fire of semi-automatic weapons, but it doesn't provide technical definitions for what that phrase actually means. Binary triggers are explicitly banned. The law mentions them specifically. But what about competition triggers featuring lighter pull weights? What about muzzle brakes that reduce recoil and allow faster target reacquisition? What about enhanced buffer systems that create smoother cycling? The Oregon Department of Justice was supposed to issue clarifying guidance on these technical definitions. As of late 2025, they haven't. In the absence of clear regulatory guidance, county prosecutors are developing their own interpretations. Multnomah County's district attorney's office has indicated they're adopting a broad interpretation. Essentially, anything that makes shooting faster or easier could potentially qualify as prohibited. This creates a situation where identical equipment might be legal in one county but restricted in another, depending entirely on how local prosecutors choose to interpret ambiguous statutory language. The database system, being built in plain sight. Oregon is establishing a centralized database containing detailed information about firearm transactions, and the March 2026 permit system provides the data collection mechanism. Every permit application requires specific information: make, model, and serial number of the firearm being acquired, complete address and background information, personal references. All of that data flows into a state database that will contain records of every legal firearm purchase in Oregon going forward. The law explicitly states this information is designated for administrative purposes only and cannot be used to create a registry of owners. But the definition of administrative purposes is broad enough to encompass nearly anything. Permit data can be shared with federal agencies, other states, and local law enforcement as necessary, a qualifier that provides enormous discretion. The infrastructure for comprehensive tracking is being established under the guise of permit administration. Whether that infrastructure eventually gets used for purposes beyond its stated intent depends entirely on future political decisions and legal interpretations. So here's what's actually happening in Oregon while attention remains focused on the most visible aspects of new firearm regulations. A comprehensive secondary framework is emerging that creates financial barriers, legal ambiguities, proof of ownership challenges, insurance coverage gaps, interstate travel complications, undefined enforcement standards, and centralized data collection systems. March 2026 represents a critical implementation deadline when many of these provisions take full effect, yet the infrastructure to comply with them, like trainer certification programs, doesn't exist yet. The costs of compliance could easily exceed $900 per transaction, potentially pricing working-class citizens out of exercising constitutional rights, regardless of their legal standing. And the burden of proof for grandfathered items has shifted entirely onto owners, many of whom lack documentation for decades-old legal purchases. These aren't hypothetical concerns or distant possibilities. They're practical realities emerging from regulatory implementation that will affect thousands of Oregon residents within months. Whether courts ultimately resolve these conflicts, whether the state provides clearer guidance, or whether citizens simply navigate an increasingly complex legal landscape remains to be seen.